Hey there, my name is Sahil Malhotra, principal attorney at Drishti Law. Today, we're going to talk about the basics of trademark infringement and how it can affect cannabis and CBD brands. First, trademark infringement is a legal claim that is governed by Section 32 of the Lanham Act. By definition, it is the unauthorized use of a mark that is either same or similar to a valid and legally protected trademark and has caused a likelihood of confusion. An infringer is one who uses the trademark without the consent of the owner. To have a validly registered trademark, first, there must be a valid and legally protectable trademark. As long as the mark is registered on the principal register, it is presumed to be valid, and the burden to show the mark is protectable is on the infringer. Be mindful, if the infringer is able to prove that a registered mark is not legally protectable, it will be an affirmative defense against the infringement claim. The defendant or infringer must have used the plaintiff's mark or something similar. The plaintiff must show that the defendant is using or has used the infringing mark in connection with a sale without the plaintiff's consent. The infringing use must be in commerce, which means the use must affect interstate commerce. There must be a likelihood of confusion amongst consumers due to the unauthorized use of a mark that is similar or same to the plaintiff's mark. Each federal circuit analyzes a likelihood of confusion based on the DuPont factors, which is a precedent often used in federal circuit and lays out 13 factors that are essential to a complete analysis of a possible confusion. CBH International, the plaintiff, is the owner of the brand Uncle Bud's, which is federally registered for use in connection with its industrial hemp products, CBD topicals, edibles, etc. As a reminder, to receive a federal registration for cannabis or CBD related brands, your product must contain less than 0.3% of THC and must not explicitly imply the sale of cannabis. The defendant is a retail store that appears to provide goods and services similar to a garden center while developing a niche in the cannabis grow operations. The shop sells merchandise with their name Uncle Bud's labeled on t-shirts, hats, etc. The courts will apply the DuPont factors to determine whether there is a likelihood of confusion between Uncle Bud's the grow shop and Uncle Bud's the CBD and hemp provider. The DuPont factors were created to help the courts determine there was a customer confusion and thus trademark infringement. Although there are up to 13 DuPont factors, we'll review the 7 that are most relevant and often given more weight during the analysis by the courts. Number 1, the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. The proper test is not a side-by-side comparison of the marks, but instead whether the marks are sufficiently similar in terms of their commercial impression, such that the person who encounters the marks is likely to assume a connection between the parties. Here, both parties label their goods as Uncle Bud's. Number 2, the similarity or dissimilarity and nature of goods or services as described in an application or registration or in connection with which a prior mark is in use. It's not necessary that the products or services of the parties be similar or even competitive to support a finding of likelihood of confusion. Instead, a likelihood of confusion can be found if the respective products or services are related in some manner and or if the circumstances surrounding their marketing are such that they could give rise to the mistaken belief that they emanate from the same source. The court could determine that the defendant's mark in relation to its products is related to the CBD products sold under the plaintiff's mark. It is possible that consumers will believe the t-shirt and grow shop emanates from the federally registered CBD brand. Number 3, the similarity or dissimilarity of established likely to continue trade channels. When a registration or application does not contain limitations describing a particular or class of customer, the goods or services are assumed to travel in a normal channels of trade. With the increase in availability of goods and services across multiple channels of commerce, this factor will likely help the plaintiff. The strength of the plaintiff's mark. A mark's strength is measured both by its conceptual strength, distinctiveness, and its marketplace strength, secondary meaning. Here, CBH can claim their mark is nationally known. Its products are sold on multiple online platforms and retail stores. The extent of potential confusion. In a likelihood of confusion analysis, the board and federal circuit are not concerned with mere theoretical possibilities of confusion, deception, or mistake, or with insignificant situations, but with the practicalities of the commercial world, where the goods or services are the type that would be marketed to and purchased by significant numbers of purchasers. The potential for confusion cannot be deemed to be insignificant. The court will likely lean on the plaintiff's side again, as due to the practicalities of the commercial world in the cannabis industry, there's a likelihood that the marketing of goods by both the plaintiff and the defendant would overlap and cause potential confusion. The nature and extent of any actual confusion. Although a showing of actual confusion is not necessary to establish a likelihood of confusion, a showing of actual confusion would of course be highly probative, if not conclusive, of a high likelihood of confusion. The absence of any reported instances of confusion is meaningful only if the record indicates appreciable and continuous use by applicant or respondent of its mark for a significant period of time, the same markets as those served by the opposer or petitioner under its marks. The sophistication of consumers. When products are relatively low priced and subject to impulse buying, the risk of likelihood of confusion is increased because purchasers of such products are held to a lesser standard of care. Other factors such as the defendant's intent and inference of bad faith requires something more than mere knowledge of a prior similar mark, or established fact proving the effective use will be also under consideration. You can avoid trademark infringement by choosing a mark that is suggestive rather than descriptive, and by doing comprehensive search before making an investment in your trademark. Infringement on someone else's trademark can be very costly, and it can be avoided with the right help from an attorney. If you would like to hear more about trademark infringement and see if I can be of any assistance to you, please feel free to make a booking through the link provided below.